What are your intellectual property rights as a musician? When is someone liable for copyright infringement? This can be a very complex assessment. The appeal case of EMI Songs Australia Pty Ltd and Larrikin Music Publishing Company is in focus today. We are looking at how infringement by reproduction is assessed in musical works as opposed to other kinds of works. In this case, Australian band Men at Work argued whether their well-known flute riff heard in their recorded version of Down Under involved a reproduction of a substantial part of the Kookaburra Sits in the Old Gum Tree song to constitute copyright infringement under the Copyright Act. Larrikin owned the copyright in Kookaburra and won, claiming damages for copyright infringement by EMI and Men at Work. So what legal rights does a musician have? Section 13(1) of the Copyright Act provides an exclusive right to an inventor over their work and any reproductions of it in material form. This includes a sound recording of the work as noted in Section 21(1). This sound recording is deemed copyright infringement if you do not own or license for the work, which is provided for in Section 36. The court uses three main elements to establish copyright infringement. 1. Identify the work in which copyright subsists in Section 32. The court determines whether it is an original musical work in which copyright subsists. A melody, excerpt, or phrase is sufficient. Kookaburra is an original short musical work published as a 4-bar round sung by groups of voices. The second element is identifying the alleged infringing work the part copied. Is there an objective similarity between the two works and a causal link in reproduction? The court compares the original work against the new work as an expression, not the underlying idea. This is to identify whether a recognisable part exists in Down Under or Kookaburra. They looked at the melody, key, tempo, harmony, structure all separately. Comparing a balance of similarities and differences is quite complex. The defence argued too much focus was on the 2-bar melody with a failure to consider major differences in harmony, key, lyric structure and tempo as a 93-bar piece. Third element was the part taken a substantial part of the copyright work in Section 14(1). This is a question of fact which favours quality over work taken, not quantity, and was deemed that the 2 bars in question constituted 50% of the makeup of Kookaburra as the principal melody and therefore was in breach. So how does this compare to other works? This decision, alike the decision of Marvin Gaye Estate and Robin Thicke and Pharrell Williams, raised different arguments as to why some cases are brought before the courts for copyright infringement and others are not. For example, electronic dance artists who use the same beats and melody or a large percentage of today's greatest hits commonly use the well-known 4-chord progression as the basis for their songs are again not deemed copyright infringement. I would be mostly happy to hear your opinion on this by commenting on this video. Thank you very much.